Last week, governors of Virginia, West Virginia, and South Carolina sent their National Guard troops to Texas, to its border with Mexico.
California was actually the first state to enact what we might think of as an anti-immigrant law. It was a California law that criminalized the unlawful hiring of people who were not authorized to work. Prior to 2001, a lot of federal immigration law was really bipartisan in nature. They could be enacted in times of divided federal government by one party controlling Congress, but another party controlling the executive. That's a description that is accurate from 1965 through 2001. But after 2001, immigration becomes a topic somewhat like abortion, right? That is, once you say the topic, you can tell where people fall on that spectrum by virtue of the political party affiliation. Yeah, it's a great question. 2012, I think, was a very important year for state and local immigration lawmaking. You had a couple things happening all at the same time. So in one sense, your question is based on a premise about which there is significant disagreement. That is, what does it mean to actually abdicate responsibility over federal immigration? Because you would think that something so important that the Constitution would have lots of mentions of it. The Constitution never actually says the word immigration at all. Until the Civil War and until the 14th Amendment was added to the United States Constitution, federal citizenship, United States citizenship, was not nearly as important as many historians will tell you than state citizenship.
Did you know that until after the Civil War, that is, about the initial 100 years of our nation's history, the U.S. government, our federal government, did very little to regulate immigration? As some historians tell us, this may be because federal regulation of immigration was seen as just too darn close to federal regulation of slavery, and that's why matters of immigration were more or less handled by our states. Hey there, News Peelers. Today is June 9th, 2023, and this is Adele, your host at the History Behind News podcast. Aren't you tired of the repetitive news on TV and social media? They just go over the same dramatized developments all day long. Do you ever wonder what happened before our news? I mean, how did we get here? They say if you don't know your history, you're bound to repeat it. So while others cover the news, I uncover its history. I call this peeling the history behind news, which we accomplish in weekly conversations with distinguished scholars who delve deep into history to give us their fascinating perspectives from our past. I'm committed to making in-depth history that are researched and written by scholars, enjoyable and accessible to everyone. So grab a cup of coffee or your favorite drink or both, and let's get into it. Texas Governor Mr. Greg Abbott has asked for help at the border of his state with Mexico. In addition to Virginia, West Virginia, and South Carolina, other GOP-led states such as Mississippi, Iowa, Tennessee, Nebraska, and Florida have offered help as well. Back in March 2021, Governor Abbott launched Operation Lone Star to, quote, respond to a rise in illegal immigration, unquote. You can find much information about Operation Lone Star at the Texas Indigent Defense Commission, which is a webpage on the texas.gov website, and I have dropped a link for it in the detailed caption of this episode. According to the New York Times, through this program, Governor Abbott has sent the National Guard and the state police to the border and has employed Texas trespassing laws to arrest migrants who travel through private land in Texas. And then the New York Times adds this, quote, but states cannot enforce federal immigration law. That is up to the federal government, end quote. That is a good point. The New York Times is right. America's immigration laws are written and enforced by our federal government. But I have an equally important point to bring to your attention. What if our federal government abdicates its responsibility in enforcing immigration laws, in protecting our borders? This is not a crazy question at all. As my guest, Professor Gulasekaram, explains, this is, in fact, the very claim that Republican governors of Arizona and Texas have made, that our federal government has abdicated its responsibility in matters of immigration. And if that happens, then what? Well, so far, Governor Abbott has not declared that Texas is being invaded, but far-right conservatives have been pushing him to make this very declaration. To better understand the history of the tension between U.S. states and our federal government when it comes to immigration, which is a highly polarizing issue now, I spoke with Mr. Gulasekaram, a professor of law at the Santa Clara University School of Law, where he teaches constitutional law and immigration law. Professor Gulasekaram is co-author of the leading immigration law casebook used in law schools, which is titled Immigration and Citizenship, Process and Policy. And he is also co-author of the new Immigration Federalism, a book that provides an in-depth empirical and theoretical analysis of the resurgence of state and local immigration lawmaking, which is the subject of our conversation for this episode. And here's something super cool about Professor Gulasekaram. In addition to everything that I already mentioned about him here, and get this, he's the co-founder of the World Children's Initiative, Inc., a nonprofit organization dedicated to improving health and educational infrastructure for children in developing areas around the world. I just think that's really awesome. Great job, Professor Gulasekaram. Click the link in this episode's caption to learn more about his organization, the World Children's Initiative. Also, to learn more about Professor Gulasekaram, you can visit his academic homepage, the link for which is provided in the detailed caption of this episode. And by the way, Professor Gulasekaram will soon be leaving Santa Clara University School of Law to join the University of Colorado Law School. So, stay with me as Professor Gulasekaram and I peel the history behind this news. Professor Gulasekaram, it's a pleasure to have you on our program. Thank you for taking the time for this conversation with me. To understand the role that our 50 states could potentially have in regulating immigration, I think we got to start with some basic questions, the answers for which may actually turn out to be quite complex. So let's get into it. What is federalism?
Thank you for having me, first of all. You started with a question that is huge, broad, has lots of different perspectives. But I think the simplest answer that one can give is federalism is the idea that power is allocated and authority is divided between different levels of government. So in the United States, our version of federalism, often called our federalism in legal literature, reflects the idea that governmental authority in the United States is divided between the federal government, the national government, constituted of Congress, the Supreme Court, the executive branch, and then the states, right? The 50 states underneath it. In a famous Supreme Court opinion, Justice Anthony Kennedy once said that the framers of the Constitution, quote, split the atom of sovereignty, unquote, between the federal government and the states. And so that's the idea of federalism. It's easy to state in those abstract terms, much more difficult and complicated to apply to contemporary.
And if I may stop you here, what you just shared with me is easy to comprehend. Why is this a complex issue then?
Right, because I think one of the reasons it's so complex is that abstract or general formulation doesn't exactly tell you what the metes and boundaries are of federal power versus state power. What do you do when states and the federal government are engaging in concurrent regulation in a particular area? Are there areas that are exclusively for state control, exclusively for federal control? The Constitution doesn't really provide very clear answers to all of these questions. And especially as our society, our nation, our country has expanded geographically, we've developed technologically, all of those things. These questions, these regulatory questions have had significant there's been significant controversy and complication as to how to apply those general principles.
So if the Constitution doesn't clarify this, then this area is fraught for litigation, kind of like constitutional law issues left and right.
That's right. And this is why many types in many regulatory areas, you get questions over the extent of state versus federal power. This is not unique to, I know we're going to be talking today about immigration, but this is certainly not unique to the immigration sphere. Think about any area of regulation, products liability in torts, criminal law, environmental regulation. In all of these areas, you are going to get disputes over where federal authority might start and end and where state authority might start and end.
So you mentioned immigration, so let's get into immigration. In the Constitution, is there any mention of immigration?
It's surprising, I think, because immigration is so far at the top of our current national agenda, and occupies so much space in our political discourse. You would think that something so important would have that the Constitution would have lots of mentions of it. The Constitution never actually says the word immigration at all. The closest
for a nation of immigrants, this is not in our Constitution. That's interesting.
Right. The closest the Constitution comes to mentioning immigration is the word migration, and that is in the Migration and Importation Clause of Article 1, Section 9. That clause says the migration or importation of such persons as any of the states now existing shall think proper to admit shall not be prohibited by Congress until the year 1808. That clause, though, even though it generally talks about migration of persons, is clearly is one of the clauses in the Constitution, including the 3/5 clause, that is really intended to be talking about slavery without mentioning the word slavery.
Oh, that's why I said the year 1808.
That's right. It prohibits congressional regulation of slavery until the year 1808. And in fact, Congress did begin regulating the movement of slaves into the United States from foreign countries in 1808. But other than that, the only other mention of something that is related to immigration would be the naturalization clause.
How to become a citizen.
Right. It says that Congress has the power to establish a uniform rule of naturalization. So certainly Congress has the power to make citizens, that is to tell us who amongst the non-citizen population and under what conditions those non-citizens can become citizens. But that doesn't necessarily tell you that Congress has the power to control movement into the nation or exclusion from the nation.
Yeah, it's very vague with respect to those two areas you mentioned. This is on a bit of a tangent, but I just wanted to make sure that I understand this. The clause that you mentioned about slavery that prohibited Congress from making any laws about it until the year 1808, it was sort of set up to give Southerners sort of a compromise that here, sign on to our Constitution. This is a compromise. We won't do anything about slavery till 1808, right? That's sort of the backdrop to that.
That's right. And certainly this is not my area of expertise, but that is the commonly understood explanation for why that clause and other clauses like the 3/5 clause are in the Constitution. These were compromises necessary to get all of the states, including the slavery, the states in which slavery was quite important to their continued economic survival, and there was significant resistance to the Constitution without those forms of compromises in them, that those clauses were added to get those states on board.
I see. Thanks for explaining that. I was just curious. Let's get back to our regular programming here now. What is immigration federalism? I've heard this before.
Yeah, so immigration federalism is the term generally used within legal academic circles, but fundamentally it's just trying to describe the area of law and constitutional adjudication, which is trying to figure out what exactly is the room for states and localities to enact immigrant or immigration-related policies. So, for example, can Arizona create, as it did in 2010, an omnibus enforcement law against unlawfully present non-citizens? Can California cities, on the other hand, can they have non-cooperation or sanctuary laws? So that all of those laws, and whether they're legal or not legal, those fall underneath the broad umbrella of immigration federalism.
Is the term immigration federalism and its sort of related research, is this only in the academic arena, or is this real litigation going on that, goes up to Supreme Court?
Yeah, this is very much both an area of academic study, but certainly on the ground, this is something, especially over the last 2 or 3 decades, has been an active area of both policymaking and litigation. And so on the one hand, you can think of, just thinking about the last couple decades and even the last several years, there have been laws that, for example, provide driver's licenses to any resident of a state, regardless of their immigration status, provide access to higher education or education financing, regardless of immigration status. And then you have, on the other hand, laws that engage states and localities in immigration enforcement that might, for example, prohibit non-citizens or landlords from renting to non-citizens, attempt to keep unlawfully present non-citizens out of public schooling. All of those are examples of laws that have been enacted in the last 10 to 15 years and have been under significant litigation in federal courts.
Oh, wow, that's fascinating. So that's sort of an indirect way of regulating immigration without really having laws specifically on it. So let's get into this history. We'll be right back after a short break to talk about states' participation in immigration legislation and enforcement since our founding. We'll be right back. Do immigrants commit more crime than native-born Americans? Do you think they do? If you think that, you're not alone. Since the 19th century, many Americans have claimed that immigrants increase crime rates in America. And this issue has been studied since the early years of the 20th century, including specifically for the state of Texas. In Season 3, Episode 18, my guest, Professor Jennifer Chacon, digs deep into the history of immigration and crime. As she explains it, the immigrants of our past, who native-born Americans claim to be criminals, were Irish, Italian, Greek, Russian, Polish, Jewish, Chinese, and other ethnicities and nationalities that today, for many generations, are themselves native-born Americans. I've provided a link to this fascinating conversation in the detailed caption of this episode. Now, let's get back to our conversation with Professor Gulasekaram. Professor Gulasekaram, what roles did our states play in legislating and enforcing immigration? And perhaps I'm using the wrong words here, legislating, quote unquote, and enforcing. I just want to know, were they involved since the founding of our nation?
Yeah, so one of the things that's quite remarkable about when you look back at the history of state and localities and their relationship to immigration is that when you look at the first 100 years of the Republic, the federal government actually did very little regulation of immigration, and certainly not in the ways that we understand it today, which meant that what we mostly might think of as immigration regulation was done at the state and local level. Now, this was not uniform throughout the existing states at that time, but if you do a survey, and it is certainly not my work, but other notable scholars, including Gerald Newman, who's at Harvard Law School right now, has written about this. But if you look back at that first century of the Republic's existence, what you'll see is a lot of state and local laws that controlled, for example, the regulation of convicts coming into a locality, the regulation of people who might be too poor or were likely to become, as the legal term is used, likely to become a public charge. That is, they were likely to use public benefits. There were laws that regulated the movement of people because they were going to spread contagious diseases or required quarantine of people.
Sounds like Title 42.
Yeah. Those are the first laws that eventually became the authority that we now see in things like Title 42. And then, of course, during that first century, right before the Civil War, regional regulations that relating to slavery and the movement of free blacks across the United States, and of course, fugitive slaves that across borders. In many ways, these were the regulations that one might argue constituted the immigration laws of the first century of the Republic's existence. It's only after the Civil War into the 1870s and 1880s that the federal government starts to regulate immigration in the ways that we would understand it today.
So let's go back here. I have a couple of, I guess, burning questions. Mm-hmm. First, you said that the federal government did very little in the way of what today we would think of as regulating immigration. Is this because immigration wasn't a big deal in the first 100 years of our republic before the Civil War?
So there's certainly lots of different inputs and explanations. One was that there was a general policy of wanting more people to populate the United States, at least from certain areas, specifically Northern Western Europe, or places that were familiar to the people already in the United States, to help with the expansion of the United States. The federal government, though, at that time, the other explanation that is often given by historians is that federal regulation of immigration was seen to be too close to allowing general federal regulation of the slave trade in general. And therefore, while slavery existed, many historians have argued it was not politically feasible for the federal government to enter into immigration regulation. This is why some would argue that the real first federal immigration laws, the first comprehensive federal regulation of admission into the United States, occurs in 1875 after the Civil War, after the Reconstruction Amendments, when slavery is now no longer on the table.
Even though a potential federal regulation before the Civil War may not have been regarding slavery, it was just too close to that topic for Southern states to be comfortable with it.
I think that is certainly one of the more persuasive explanations proffered in the academic literature.
Wow, that's fascinating. I would have never thought that. I don't think it's something that intuitively comes across when you read history or when you look back at U.S. immigration history. My second quote unquote burning question that I had for you after you explained the first 100 years of our immigration history is this. Different state level laws or regulations, local ordinances or what have you relating to immigration, right? Let's take that back to my personal experience as a lawyer, patent law. You can't have 50 patent laws in our 50 states. Like you have a patent in Arizona, but not in New Jersey. How does that even make sense, right? So how did this make sense? You can't have, well, back then there weren't 50 states up to 1870, whatever. They eventually grew to 20 some states. How could you have different immigration regulation for New York versus Virginia? So I guess, I don't know, French Huguenots could come to North Carolina, South Carolina, but not to New York. And then how did that work?
Yeah, it's certainly not a way of thinking about immigration and a state of affairs that is easy to imagine today.
Yeah.
It's very foreign to the way we understand immigration. And as you said, sort of the practical necessity maybe of a uniform set of rules with regards to to both entry and then the terms and condition of staying and then exit. That said, that is fundamentally what it looked like prior to 1870. there were, for example, there was a Supreme Court case that upheld a New York law that required certain information from passengers landing in New York. This is an 1837 case, and the Supreme Court said it's okay for the state of New York to demand certain information from passengers landing at New York Harbor.
Such as?
So they, at that point, they were looking for information as to whether the passengers would be dangerous. But the broader law that was at issue in this case, it's called New York versus Milne. It's an 1837 Supreme Court case. The broader law was a state law that attempted to regulate whether passengers disembarking in New York were going to be, for example, paupers, that is, too poor to land, had certain diseases, etc. And these were not uniform throughout all of the landing ports in the United States. So it's entirely plausible that somebody could land at one port and be subject to certain regulations, and land at another port and be subject to maybe similar, but not necessarily the same regulations, right? So this was, so you're right. This was not a situation where one could possibly say that there was a uniform set of regulations that a non-citizen or a person coming from a foreign land would face when they came to the United States. And obviously, this is saying nothing about the land borders of the United States at that time, to the extent they existed, where people could cross into territory that would later become the United States, but at that time may not have been the United States.
Oh, like private lands that they could traverse over to get into federal sort of territory or states, America, right? Is that what you're referring to?
Into the territory that would become the United States, right? And so, yes, you're right. There was no real uniformity prior to the emergence of a robust federal system of regulation in the 1870s, 1880s into the 1890s. Even so, even during that time of transition, a lot of the federal bureaucracy was dependent on these state systems, these state controls over ports, over disembarkation points. And then it was only by the late 19th century that the federal bureaucracy over immigration became more robust in the ways that would be more familiar to us today.
I want to ask you a technical question that may be telling about some of the details out of what you were just describing. So how did an immigrant become a citizen? Let's say, you land in South Carolina, it's 45. Was there a different set of criteria for becoming a U.S. citizen than, let's say, if you landed in New Hampshire? Or was there a federal was there a CFR for this or something to that effect,
So the one thing that Congress did enact from the very beginning of the Republic were using its naturalization power, that is the power given to Congress.
Which was in the Constitution.
That is in the Constitution.
Yeah,
Congress did use the naturalization power and had always had, ever since the beginning of the Republic, laws that regulated the conditions under which somebody who was foreign-born could become a citizen of the United States. Now, not surprisingly, at the beginning of the Republic, through the Civil War, and even afterwards into the 1950s, these were racially restrictive laws. And at the beginning of the Republic, only white people could naturalize. After the Civil War, white people and the descendants of people of African descent could naturalize. And then, in a famous set of cases from the late 1800s through the early 1900s into the 1950s, naturalization was still racially restricted. That is, not everyone could become a citizen. Most famously, Asian immigrants could not become citizens. Indian immigrants from the country of India could not become citizens. There's a famous set of Supreme Court cases which verified both of those things. And this was contested. Territory until the 1950s, after which federal immigration law removed the racial restrictions on naturalization. But to go back to your question, yes, there were federal laws that existing from the time of the creation of the republic, which detailed when people could naturalize. But the important thing, I think, to also add to my answer here is that until the Civil War and until the 14th Amendment was added to the United States Constitution, federal citizenship, United States citizenship, was not nearly as important as many historians will tell you than state citizenship. So to become a citizen of a state may have had more consequences than to be a citizen of the United States.
Well, I got to ask this. Give me some examples, like how? I mean, consequence, like in your practical everyday life, it was more important for me to be from, let's say, New York than to be of the United States. This is before the Civil War?
Right. I mean, obviously, we're speaking in broad generalizations here.
Yeah.
But one way of understanding what happens after the Civil War and the Reconstruction amendments, especially the 14th Amendment, is that it fundamentally restructures the importance of membership in the federal government. That one could reasonably say that state laws and state regulation were the prime regulatory systems, the prime legal systems that governed everyday life for most people at that time. And certainly this is one of the reasons why state laws regarding slavery up until the Civil War could exist, right? Because the federal government had no power to tell the state to do something differently, right? And so, and this was a time before the Bill of Rights in the federal Constitution applied to the states, and so states often had rules that were in variance with each other and with the federal government with regards to rights that we now take as fundamental rights protected by the Bill of Rights. This is
I'm sorry, our Bill of Rights did not apply to states before the Civil War?
That is correct.
Wow.
So until the 14th Amendment, and even after that, because it was a slower process of courts actually deciding which parts of the Bill of Rights applied against the states, the Bill of Rights was seen in the Constitution as only a prohibition against federal government action. In fact, you can see this in some of the wording, right? So when you look at the First Amendment, it says Congress shall not. And so states might have had similar types of restrictions in their own state constitutions. But for example, if you were in a particular state and the state did something and you wanted to claim that the state was violating your freedom of expression or your freedom of religion, you could not, prior to the Civil War, make a federal constitutional claim against the state. You would have to raise a claim underneath a state constitutional provision or a state law provision.
So going back to our discussion of immigration, we digressed to the Bill of Rights, but that was fascinating. After 1875, the federal government takes on a more robust stance in regulating immigration. In the minute we have left of this segment, what I want to know is something that one of your colleagues, Professor Jennifer Chacon, shared with me. The Dillingham Commission that came in the 1910s and 1920s. 1920s was famous, well, really infamous for immigration scares. Did states play a dominant role in that, or was that mainly sort of a federal regulation matter?
I'm sorry, I apologize, and I'm not sure I understand when you're talking about that. Are you referring to the 1875? No,
I'm going forward. No, thank you for clarifying that. I'm going forward to the 1920s and prior to that, 1910s, where immigration became a huge political, heated national issue. What I want to know is that were states at that time enforcing their own local laws and regulations, or was by then the federal government now in control of immigration.
Yeah, I think it's fair to say that by the 1920s, the federal government had become the prime, if not exclusive, regulator of immigration. And that's a story that really starts, as Professor Chacon had mentioned on your podcast, in 1875 with the first federal enactment, a law that prohibited the immigration of people who were likely to become sex workers, deemed prostitutes at that time, and another category of immigrants that's now escaping me right now is the first law, and followed
criminals.
Yes, that's right, convicts,
Yeah.
and then followed in short order by the Chinese Exclusion Acts. And so by the time you get to the 1900s, early 1900s, the court seems to have settled on the idea that, at least with regards to admission, the terms and conditions of staying, and then exclusion, that is deportation, right, of kicking people out, that the federal government is the prime, if not sole, regulator of that area. But by the time of the 1920s and the Dillingham Commission, there is a concern with the type of people that are being let in under current federal immigration laws. In the late 1800s into the early 1900s, it is at that point the United States experienced the highest number of foreign-born as a percentage of the United States population that the United States has ever faced, including up to today, right?
Oh, wow.
As a percentage of the population. And during that time, the Industrial Revolution, the place where people are coming from is changing. It's no longer predominantly Northern and Western Europe. It's starting to become Southern and Eastern European. And the people who had already been in the United States, the people in power in the United States, along with the eugenics movement, concerned about this new stock of immigrants coming. And this commission is constituted to study immigration law, and comes to the conclusion that the best way to handle this is to think about what the percentages of people were in the United States near the turn of the century, and use that as the basis for future migration flows, thereby privileging Northern and Western European immigration, while diminishing immigration from all other areas. And at this time, there are already laws that prohibit immigration from all over Asia. And so you get a very racially constructed group of Americans coming in that time period.
And these laws were mostly against Catholics, Orthodox Christians, and let's say Jews and Asians, particularly Chinese.
Yeah. At
Interesting.
the federal level is Chinese exclusion, and then you had the way the quotas worked. It essentially privileged all immigration from Northern and Western Europe, and diminished immigration from places like Italy or Eastern Europe.
I see. We'll be back after a short break to talk about the rest of this story that takes us into the 21st century.
We hope you are enjoying this podcast. And if you are, then why not treat us to a cup of coffee? That's right. For the price of a cup of coffee, you too can become a monthly supporter of the History Behind News podcast. We rely on your support to continue this program, to continue peeling the history behind our news. Supporting us is easy. Just click the support link in the detailed caption of this episode. And while you're there, check out the information about our guests and other attributions and links. And thank you.
Professor Gulasekaram, how did the roles of state and local governments become such a hot topic in the opening years of the 21st century? Like, I remember 20 years ago, 17, 18 years ago, state involvement became really in the news, even not even in sort of academic circles.
Yeah. So, important to note that there has always been some level of state and local involvement. Much of the immigration that we understand today is a product of post-1965 changes to immigration laws. It's underneath those laws that people like you and me got to the United States.
Yeah, amen.
So those laws opened up immigration to the entirety of the world to come to the United States, but they also started enacting restrictions on the numbers of people that could come from all the places, all the countries around the world. Now, as you can imagine, this opens up immigration for places that previously could not get in the United States. But on the other hand, the numerical restrictions really operate to restrict what had been routine migration flows from countries from which there had been geographic and historic relationships. For example, Mexico, which had often had people coming to the United States cyclically. And so it's post-1965 into the early 1970s that the idea of the unlawfully present immigrant in the ways that we understand it today really starts to take root. In the 1970s, California was actually the first state to enact what we might think of as an anti-immigrant law. It was a California law that criminalized the unlawful hiring of people who were not authorized to work. It gained significant notoriety. It goes to the Supreme Court. It was upheld at that time, but later the federal government starts to regulate in that area, and so laws like California become what's known as preempted. That is, the federal government regulates in that area, and state laws are can no longer be enforced. Also, during that era,
even if the state law is indirectly affecting that area.
That's right. So this is known as preemption doctrine. It's a function of article of the original Constitution, which tells you that the Constitution of the United States and federal laws are supreme over other forms of lawmaking, including state lawmaking. And this has been understood by the courts to mean that when the federal government enacts laws, it can preempt state laws. That is, it can exclude state laws, even state laws that happen to be similar to that federal law, even state laws that are serving the same purpose of that federal law. And this is essentially what happens with California's initial attempts in the 1970s to regulate unauthorized employment. At that same time, Texas attempts to exclude unlawfully present children from attending public schools. This becomes the famous Supreme Court case of 1982, Plyler versus Doe, still a very important part of our constitutional framework, in which the court says it is unconstitutional for states to exclude unlawfully present children from attending public schools in the United States. So I don't want to suggest that state and local involvement is just a factor of the last few years. And then again in 1994, California enacts its Proposition 187, which at that time gained significant notoriety. California attempt to exclude unlawfully present non-citizens from access to any social services and other types of state benefits, struck down by a federal court and later superseded by federal enactments in 1996. But I think one can fairly characterize all of those as, in a sense, isolated or low-level attempts to, obviously California is a huge state, Texas is a big state, but they didn't, I think, capture, other than Prop 187, capture the national attention in the way the state and local immigration laws of the last 10 to 15 years have. Post 9/11, post 2001, state and local immigration laws, as you rightfully say, start to gain significant national media attention. They start to occupy a significant part of federal dockets in terms of litigation. And we still talk about them today, right? What is the role and what's the appropriate leeway for state and local regulation? And that's even being tested as we speak by states like Texas and Florida, which are enacting these sorts of laws. So your question was, what accounts for this rise? And I think there are several different responses. A co-author of mine and I, Karthik Ramakrishnan, who's a political scientist at University of California, Riverside, were interested in this question. And one of the things that we saw was that prior to 2001, a lot of federal immigration law was really bipartisan in nature. They could be enacted in times of divided federal government by one party controlling Congress, but another party controlling the executive. That's a description that is accurate from 1965 through 2001. But after 2001, immigration becomes a topic somewhat like abortion, right? That is, once you say the topic, you can tell where people fall on that spectrum by virtue of their political party affiliation.
Yeah.
So you get significant polarization, which leads to federal stasis. No federal immigration law to speak of really since 1996, right? It's a very long time. We're now going 30 years from that moment. And this leaves the opportunity for states and localities to really become robust in their immigration regulation. And it's also at states and localities where you're more likely to find pockets that are more closely controlled by political partisans, right? Where you can get enactments based, by pushing it through, a red state where the legislature and the executive are both controlled by the same party, or a blue state. And so you can get these sorts of enactments. That is one explanation for why you start to see a significant rise in them after 2001. And certainly with regards to, with the federal policies that are enacted during that time, states becoming much more robust in their attempt to push back against that federal policy by the use of state and local immigration policies.
In this discussion of 21st century states' involvements in immigration, I've seen the year 2012 mentioned several times, including your own writings. What happened in 2012? Was there a shift?
Yeah, it's a great question. 2012, I think, was a very important year for state and local immigration lawmaking. You had a couple of things happening all at the same time. One is that's the year that the Supreme Court decides a case called Arizona versus United States. And in this case, the Supreme Court strikes down most, but not all of Arizona's SB 1070. SB 1070 in Arizona was a state-level immigration law, an omnibus immigration enforcement law by the state of Arizona that attempted to regulate unlawful migration into the state by criminalizing several aspects of immigration in the state, and then empowering state and local authorities to do things like check people's papers or arrest people on suspicion of being unlawfully present in the United States. So in the summer of 2012, the Supreme Court strikes down many of those provisions in SB 1070. It's also the same summer that President Obama, nearing the end of his first term, institutes what's now known as the DACA program, right? The Deferred Action Arrivals program, providing some relief from removal for hundreds of thousands of unlawfully present young people in the United States, and providing them the opportunity to both go to school and to seek employment in the United States during the time that DACA is active. So I think those two are just significant things that happened at that time. And at the time that Arizona had enacted its laws, it wasn't just Arizona. There was copycat legislation in lots of different states, including Georgia, Alabama, Indiana, Utah. A lot of states had that type of legislation. So it wasn't just one state. And so that's why 2012 happens to become a very important marker. It's also a time when you start to see progressive or integration-minded localities and states start to mimic the same strategies as restrictionist or anti-immigration states. That is, maybe they start to think maybe it's a good idea to look at the possibilities for state and local policies that can be, in their view, more immigrant friendly. So that's when you start to see a rise in, for example, driver's license laws that allow access to driver's licenses or IDs to people regardless of immigration status, access to higher education, or education financing, professional licensing policies in states that allow people, regardless of immigration status, to become licensed as doctors or as lawyers, right? And so you start to see all of these movements happening and really accelerating in the 2012.
So that's why you call them integrationist. These states are the reverse of states that were restrictive. They're passing legislation towards integration, right? Sort of the other side of the pendulum.
That's right. So you start to see both of these movements trying to use state and local jurisdictions and state and local authority to enact their preferred vision of immigration. Integrationists, or it's just a term other people might use other terms, but at least in my book and my co-authors and other people, you might think of integrationists as a set of policies intended to be ameliorative or pro-immigrant, to not worry about immigration status or unlawful status and simply treat people as residents of a community or of a state. And then on the other side, restrictionist or anti-immigrant, if you'd like, policies that attempt to be more enforcement heavy to deter the presence of at least unlawfully present non-citizens, and in some cases, all non-citizens from being in a locality.
And of course, all of this falls into the ambit of politics, where each state is. Let's take a break here. Stay with me and Professor Gulasekaram as we get into the perspective.
The History Behind News podcast is available on all your favorite podcast platforms. Of course, we love your reviews and ratings of our podcast, especially on Apple and Spotify. And remember, don't keep us to yourself. Tell a friend about the History Behind News podcast.
Professor Gulasekaram, in the last segment, we talked about how in the 1870s and thereafter, there were state laws restricting access to education or employment for unauthorized persons in the United States, illegal immigrants, social services, and sort of we went all the way up to SB 1070 in Arizona. I don't want to talk about any one of those specifically. What I'm wondering is this. What if the federal government sort of abdicates its responsibility to control our borders? And I'm not saying this in the political context. Literally, it just drops the ball. And, it's not supervising or implementing even immigration laws that we have. Now, let's say Arizona or whatever state is stuck with taking care of immigrants, or pick any states, right? So I don't know, what is the recourse for these states then? I told you it's not a political question, but it turned out to be a political question, right?
Yeah, Adele, I may have heard you incorrectly, but I may have heard you as saying 1870s when you meant 1970s, right? Maybe
1970s. Yes, thank you for correcting me. Yes, 1970s. Yeah.
So I think that, first of all, I think it's important to note that this claim that the federal government has abdicated its responsibility is, in fact, the claim that the state of Arizona and its governor made in 2010 when it enacted its laws. And SB 1070 is a very famous picture of then Governor Jan Brewer confronting then President Obama on the tarmac at an airport in Arizona, and she, you see her wagging her finger at Obama, and it's famously captured in media reports as Governor Jan Brewer really telling Obama that he needs to do his job, the federal government needs to do his job, and if he doesn't do his job, then Arizona is going to do the job that the federal government can't. In fact, if you look, there's a similar picture to Governor Greg Abbott meeting President Biden more recently and handing him a letter. And that letter purports to do the exact same thing that Governor Jan Brewer was doing, a decade prior. That is telling President Biden that he needs to get moving on immigration, that the federal government has abdicated its responsibility. And this is why the state has stepped in. Now, so that type of claim as a matter of political theater or a way of justifying state action, that is an age-old claim that has been made for decades, and certainly in the last couple decades, it's one that states like Arizona and Texas have used.
And it could be applied to other areas of law, for example, environment, many other things, right? That's
right. It can be applied anywhere. It has perhaps some special symbolic and other type of resonance for us because it's done by, let's say, in these two cases, We're talking about governors of border states in Arizona and Texas. Now, it's worth noting that you don't see the governor of California or the governor of New Mexico doing the same thing, right?
Because they're Democrats,
Yeah, which is to say that this idea that the federal government has abdicated its responsibility is not a claim that I think there's no way of, I think, objectively measuring and saying yes or no to that question, right? The federal government, of course, has a significant structure at the border, right? That is the entirety of the border infrastructure is based on federal ports of entry regulation, federal border agents, a significant enforcement force within the federal government. I believe federal immigration authorities are second only to the Federal Bureau of Investigation in number of federal employed federal.
Oh, wow. ICE is that big after FBI? Wow.
I think, I have to go back and look. It might be all of federal immigration authorities, not just ICE, right? ICE, Border Patrol, et cetera, right? So it's a significant federal enforcement authority. So in one sense, your question is based on a premise about which there is significant disagreement. That is, what does it mean to actually abdicate responsibility over federal immigration? Because if we take the robust federal laws that regulate admissions and deportation, federal laws that regulate asylum, federal laws that create the entire enforcement infrastructure at the border, one could reasonably say, I think, that the federal government has not abdicated its responsibility. But what we're arguing about is that it should be more. Right? That this is not about abdication. It's that there should be more regulation, more enforcement, more border walls, etc. Maybe, right, except Congress has not done so. Congress has not done much of anything with regards to immigration law, but it certainly hasn't increased the border enforcement infrastructure with regards to significantly more funding, or at least the funding that would be required to do the types of things that would make Arizona and Texas political jurisdictions happy and perhaps withdraw their claims. And maybe partly because it's a very convenient political claim to make, right? It's a very popular claim to make in those states. That
goes into the heart of nationalism.
That's right. The federal government has abdicated its responsibility. We have to step up. We have to be robust in enforcing these laws. And so I know it's a little bit of a dodge from the question you asked, but I think that is one way of thinking about this, that whether the federal government has abdicated or not is a matter of perspective and political convenience.
So let's go back to my question and answer it legally. Let's just put politics aside for a second. Mm-hmm. If it was the case, let's use a hypothetical, as we both know from law school days. Let's do a hypo here. Let's say that the federal government did abdicate its responsibility regarding immigration, which also could apply to other areas of law. Mm-hmm. The state couldn't come and say, because you didn't do XYZ per this law, that's a federal law, we're going to have our own legislation now and enforce that. That's not the recourse. The recourse is to sue the government, the federal government. Am I correct on that? You're shaking your head.
It's a great question. I'm not sure we have a great answer to it.
Seriously, we don't?
I think that in the pre-Civil War, pre-1870s time, if you look at the state of regulation at that time, one might say, drawing from that, states always had a power to regulate who comes into the state and who gets through their borders, their ports of entry. And perhaps that would justify, in a hypothetical world where there was no federal immigration regulation at all, a return to that time. Maybe, right? Yeah. On the other hand, one might say that what we've learned at that time, what our constitutional structure has divulged, is that the regulation of movement into the country, whether the federal government has regulated it or not, is still inherently a federal responsibility. So at that moment, it's not for states to regulate, but rather to use their power in Congress to lobby the federal government to do so, to tell their representatives to go to Congress to enact this sort of federal law. But still, it would not be proper for states to enact their own immigration regulation. I think
just like they would lobby for other laws, right?
That's right. That's okay. Just like any other laws. And this one in particular would be of such importance that if enough states wanted it to happen, it would clearly happen, right? Now, as everything I've just said, I'm not there. Please don't take it to mean that this is the only perspective on this issue, right? This is one person's perspective on this issue. It is highly contested territory. If you read the
contested also in academia.
That's right. If you read the Supreme Court opinions in Arizona versus United States, the 2012 case, which struck down much of Arizona's attempts to regulate immigration on its own, I think one of the opinions written by Justice Anthony Scalia, one could read it as a real strong and robust, powerful case for state-level immigration law. I think one could read it as saying states have this power and states are allowed to do what they want with regards to the regulation of the movement of non-citizens, regardless what the federal government is doing. Now, I think that's a minority position, but my point to you is that there are people within legal circles that might make that argument. I think it's an impossible argument to make in our current moment where there is not just a little federal regulation, but robust and comprehensive federal immigration regulation and regulation of the border. In your hypothetical world where all of that goes away, I think we're once again plunged into uncertainty about what the legal parameters are for state regulation versus federal regulation.
My issue, putting the ethics and politics of immigration aside, is if states have their own direct or indirect laws and ordinances regarding immigration, just like the example I shared with you about patent law, then it would be mayhem. I mean, chaos. Then immigrants would go state shopping, right? Don't go to Oregon, don't go to California, go to New Hampshire, don't go to New York, that sort of thing. That's interesting.
Yeah, I mean, in a sense, that does happen informally now. And I guess the question or the thought that I have for you in response is whether you think, and that this is a fundamental problem that courts wrestle over in this area, is this claim about disuniformity and the chaos and mayhem that would occur, is that just a good policy reason for there to be significant uniform federal legislation and only federal regulation in this area? Or does it also translate into a constitutional mandate that there only be federal regulation and one uniform policy in this area? That, I think, is most simply stated the conflict in this area of immigration federalism.
If you wanted our audience to remember just one point about immigration and federalism after everything we've talked about, what would it be?
Yeah, I think it's a broader point about immigration in general. And that is that the migration of humans has been a fact of human life and human history since the dawn of humanity. People have moved from where they've been. That all said, still, most of the world, over 97% of the world, still lives in the country and in the place in which they were born. So it's still a very small percentage that leaves and goes to other places. That, coupled with the fact that people come to the United States, even knowing that there is, for example, at our southern border, knowing that there is significant danger, significant risk of death or bodily harm, they will still come. All of this is to say, and the reason I say this is to say that even if we're talking about national immigration policy, the idea that we can enforce our way out of migration, that we can unilaterally dictate migration, I think is a fantasy. Now,
really? Oh, wow.
I think if I'm saying that about our national immigration policy, I think it goes doubly true for individual states and localities. That if we think that unilateral state policies can actually impact and influence migration in ways that are broad and meaningful, I think that is a fantasy. I think that what we should instead see, at least contemporary state and local immigration policies, especially enforcement-minded policies, really as about being able to mobilize particular political constituencies to make claims on what immigration policy should be, and to project a vision of immigration policy rather than as actual important pieces of public policy legislation. That would be the one point that I would make.
Thank you for sharing that. And by the way, yesterday, the Wall Street Journal had a report about how most developed nations, the UK, even South Korea and Japan, certainly Canada, are inviting a lot of immigrants, huge numbers, to do the work that their native-born citizens won't do. And the exception, the report stated, was the United States. Professor Gulasekaram, thank you so much for educating me and our listeners. And to our listeners, if you know of any history that could provide more perspective from the past on this subject, please share it with us and tell us what's your perspective.